Welcome to this week's Trump Trials and Tribulations. Joining you from beautiful Sausalito, California, at the foot of the Golden Gate Bridge at the old Fort Baker, which has been converted into a retreat facility. So I'm here at a resort. I don't know about the rest of you. Roger is joining from the Sconce studio, Quinta Jurecic from the Ansel Adams studio, and Anna Bauer. What room in your palatial mansion are you joining from today?
This is the special demur, the second special demur studio.
The special demurrer studio. All right, we got a lot to cover this week because there have been insubstantially important developments in just about all the cases, which are creeping along from this petty pace to from day to day till the last syllable of recorded time. Let us start with Judge Cannon, who just in time, and I want to extend personal thanks to Judge Cannon for getting this in like an hour before Lawfare. We had to go live with this. I think that's a message to all the judges in this case. 3 o'clock p.m. is a great time to issue rulings because gives us like an hour to talk about them. And if you keep your rulings to 3 pages, like Judge Cannon did today, they're very digestible, so we can read them quickly and then be ready to denounce you within the hour. So I really, we come down hard on Judge Cannon sometimes, but I really want to thank her for her diligence and attention to our needs in this episode. Roger, tell us about Judge Cannon's latest ruling, and is it a real win for the government, an apparent win for the government, a Pyrrhic victory? How should we characterize it?
I don't consider it a victory for the government. I think she made a shrewd chess move to avoid getting taken to the 11th Circuit and keeping this case on a track toward oblivion. And what happened just less than an hour ago is that she did. It was a 3-page order. She denied. This was not surprising. She denied a motion to dismiss that she heard argument in 2 weeks ago. But the important part was that it related to this aberrant jury instruction that she demanded the parties to engage with. And the parties responded April 2nd, which I think is Tuesday. And Jack Smith was very, very not just outraged about the substance of the proposed jury instructions, one of which amounted, he said, to directing the jury to acquit. And incidentally, Trump agreed with that assessment in his response. But he also did something very unusual and said, you must rule on this promptly. That's unusual in several respects. You don't usually have lawyers telling judges what they must do. And he said that otherwise she would be interfering with his right to a fair trial, the government's, and he was very clearly threatening to take her to the 11th Circuit over this. The problem, of course, with an aberrational jury instruction like one that instructs the jurors to acquit is that if they do acquit, you can't appeal that because of double jeopardy. So the question is, when do you get to challenge that? And there are some cases that say that you can challenge that on mandamus even after the trial begins, but that's a hairy thing. That's very dicey. Once the jurors are sworn in, jeopardy attaches, and if the something happens and the jury has to be discharged, it's probably all over. You can't try him again. So he is freaking out, justly, about how is he going to challenge this thing if this is her plan. And so he gave her this ultimatum, and an hour ago she said, no, I'm not going to rule on this. This unprecedented and unjust, she said. She said she signals that she will not do this until she will not make a decision prior to trial, prior to a charge conference, or prior to presentation of trial defenses and evidence. So she does plan to make this sort of a very dicey situation if she can. I think, and then she said this, she said, and bear in mind that when she asked them to engage with these instructions, she actually told them, you can brief it, but regardless of whether you disagree with me, I want you to give me instructions that incorporate these ideas. You know, it was, and even Jack Smith had to do it. He said, okay, I disagree with this, but here, so it sounds like she was pretty locked in on this. But then she says, the court's order soliciting preliminary draft instructions on certain counts should not be construed as declaring a final definition on any essential element or asserted defense in the case, nor should it be interpreted as anything other than what it was, a genuine attempt in the context of the upcoming trial to better understand the parties' competing positions and the questions to be submitted to the jury in this complex case of first impression. So I think that was the right chess move, whether or not that is made in good or bad faith. She has made it harder for him to mandamus her for failure to act, which was already an exceedingly hard thing to do. There actually is a whiff or a slender, not a whiff, but a wisp of precedent for mandamusing somebody for a judge for not acting. There is a Third Circuit case from the 1990s, and it's an asbestos case where the judge was refusing, obviously in bad faith, not to rule on a motion to summary judgment. They were a few days before trial, and the defendants, he just wanted to go to trial regardless. And the defendants did successfully mandamus him to rule. They simultaneously mandamused him to recuse, but that was so he was off the case as well. But so there is that, and then that was cited with approval by a federal court. I mean, by in a criminal case. U.S. versus Moussaoui by the Fourth Circuit. Moussaoui was the, Zacharias Moussaoui. He was the so-called 20th hijacker. They didn't actually use it there, but they cited that with authority that, yes, you can mandamus somebody for failure to rule without good cause. So there's a thin wisp there, but I think she has probably taken care of it, and now he will have to approach this with a different strategy, either mandamus during trial, which is terrible, or he could try to do a motion in limine beforehand, say, we move that you not permit any lawyer to suggest by Trump that the Presidential Records Act could constitute some sort of defense to that he could possibly be authorized in reality to possess classified documents on the theory that he had designated them as personal. You could try something like that. There are other interesting things.
And just to remind people, last week in your piece and on Trump Trials and Tribulations, we talked about, or you talked about, a Second Circuit case where they actually did mandamus while the jury was sitting over like a few hours or a weekend or something, and actually got an instruction corrected. So maybe is that the answer, that you let her go to trial with impanel a jury, and then if you get a patently unreasonable jury instruction, that's essentially a direct a direction to acquittal, you mandamus at that point.
Yes, but let me give you a harrowing scenario. Suppose the government presents its case in chief, and then the defense starts its case, is supposed to start its case. So you haven't had a charging conference yet because you aren't close enough to the end of the trial. But at the end of the government's case in chief, the defendant lawyer stands up and makes what's called a Rule 29 motion. The government has failed to make its case because, under the Presidential Records Act, he was entitled, blah, blah, blah. And when he absconded with the records, that was, as a matter of law, his decision to declare them to be personal. These are things that she believes, apparently. And then she acquits, and it's all over. So, we don't necessarily get to the charging conference. So this is a harrowing situation.
Right, which is why I think your motion in limine situation at least get her to either grant that or mandamus on that basis, so at least you don't have an impaneled jury yet.
That's right. Yeah.
All right, so this is the rare Trump Trials and Tribulation week where we start with action by Judge Cannon. Usually the bigger story is inaction by Judge Cannon, and the endless pile of motions and matters that is on her chamber's desk unruled upon. I wouldn't want to give the impression that she's been busy. How big is the pile, and is it growing, or has she put a substantial dent in it with a single 3-page order?
No, it's pretty substantial backlog. We have a sort of a monster motion to compel that Trump filed back in January. That's been fully briefed as of February 19th, I think. And they want a hearing. The defendants want a hearing in that. We have a motion to unseal that the defense have made some time back, which she tried to grant on February 6th. It would unseal a lot of redactions and exhibits that currently protect the identities of witnesses and also their statements. And of course, the government is petrified that this will subject them to harassment and intimidation and threats. There are other things about witness statements that you usually do not like to reveal, which is that the other side can sort of craft their defenses to, if they know what witnesses are going to say, they can. But actually, I think that is less of a factor here because they do know what the witnesses are going to say. But anyway, there was a motion to reconsider, and again, Jack Smith made pretty clear in the motion to reconsider. He said, if you rule against us, please stay it for 3 business days so we can consider appealing to the or remedies to the 11th Circuit. So that one too looks like he might take her up, and that's been fully briefed since February 28th. Then since then, there have been 13 motions to dismiss. 2 have now been dismissed, although the first one was dismissed without prejudice. meaning it can be re-raised in some fashion. And then there's at least, in connection with those remaining 11 motions, there's at least 9 or 10 that seek evidentiary hearings, which would be extremely time consuming. So she's got to decide whether to hold those. So those are the things that I can think of at the moment. And as a corollary of the motion to unseal, because of that, she adopted a corollary order which made it very cumbersome. She departed from the local rules and said you can no longer file redacted papers without going through a rigmarole that's very cumbersome and hard to do to meet if you're going to meet deadlines. And that's created a undocketed docket, which at the moment has about, my best guess, since it's undocketed, it's not public, 18 briefs and about 70 exhibits on it. And, if she hadn't departed from the rules, we would have, redacted versions of almost all of those. Some of the exhibits would be completely sealed. But, like I think the government said its responses were about 260 pages long. It had about 11 pages of redactions. So it's sort of that ratio. I expect 6 of those to be made public very, very shortly, but the rest seems to be locked onto there until she decides the motion to unseal, which, like I say, has been pending since February 28th.
All right. Let's go 500 miles north or so to Fulton County, where we have another judge who has a lot of motions in front of him. Unlike Judge Cannon, he does not seem allergic to ruling on motions. What has boy wonder Judge Scott McAfee been up to, Anna Bauer?
So we got 2 motions from boy wonder Scott McAfee today. The first is on the Trumps and many other defendants who joined that motion, their effort to dismiss the indictment based on First Amendment grounds. We discussed that last week. There was a hearing on it. It is a form of an argument that was already rejected by Judge
This is the one I called a loser last week, right?
This is the one that you called a loser.
Just checking.
To Ken Chesebro's attorneys' faces when they came on our podcast, but then also last week. And Judge McAfee ruled on that issue. He agreed with you, Ben, that it was a loser. He denied the motion. He went a little bit further than he did when he decided the Ken Chesebro First Amendment motion. If folks recall, as we discussed, when he ruled on that, he said basically this isn't ripe. There needs to be more factual development. Here, he agreed to at least take the facts that are alleged in the indictment and kind of look at the 4 corners of the indictment. But even doing so and drawing all inferences, in the light most favorable to the state, so to the prosecution, he ultimately said that this the allegations basically amount to speech that is integral to criminal conduct. And then as to the RICO charge, he noted, for example, that even with RICO charges, it can be First Amendment protected speech that is an overt act that would, be able to be used to be proved, to have that RICO charge proved up. And then
And that's an important reminder, kids, that, even constitutionally protected activity can be a crime if you do it with specific intent to commit a crime and if it is integral to other criminal activity. So, for example, if you go out and give a political speech to raise money, say, not to raise money for Lawfare, because all of our fundraising is entirely above board. But imagine I go out on this porch in Sausalito and I give a political speech and I say, give money to the Ben Wittes for President Fund, and then I spend that money on trinkets for me, and they have nothing to do with running for president. I can't argue, hey, you can't include the fact that I raised that money by giving a political speech, because the political speech was a scheme to raise money that I was going to steal. And so that's what the prosecutors are saying here. If political speech is integral to the commission of a crime and done with specific intent to commit the crime, you don't get to say, hey, but that was political speech. It's protected by the First Amendment. So
Right,
that's why it's a loser of an argument. It was a loser when Ken Chesborough made it. It's a loser when Trump makes it, and it lost.
It lost, but importantly, Judge McAfee also said that he didn't specifically say that he was denying it without prejudice, but in effect he did. He said, basically that his denial at this point in the proceedings does not foreclose this issue being raised later on after there is more factual development. So what he's nodding to there is that when this case goes to trial, eventually, who knows, because we still don't have a trial date, but when this case goes to trial after the close of evidence, the defense could move for a directed verdict in which they basically could raise these arguments again as a reason to try to convince Judge McAfee to acquit their clients based on, making these very similar arguments. So at that stage, there's been factual development,
Right.
and Judge McAfee
make
would
the argument to the jury that, hey,
well,
they have not shown this to be anything more than political speech. They've merely shown, they've made allegations, but they have not borne their burden of showing that it was integral to criminal conduct and that it was done with the appropriate intent. That's fine as a jury question. It's not, the case is not precluded as a matter of First Amendment law.
Right, but I think though that they can also make these arguments at a directed verdict stage, right?
Sure. Anything that you can
Okay.
argue to a jury, you can argue the jury, no reasonable jury could have disagreed with me.
Right. So the point though is that this issue can be raised later on at a different stage of the proceedings after there has been evidence that's been presented. So it's also something that could be appealed. It's unclear right now if that is something that will be appealed, but keep in mind, if the Georgia Court of Appeals takes up the disqualification issue regarding, Fani Willis and all of that we just went through, there's a weird procedural rule in Georgia appellate procedure that would allow these defendants to kind of use that case as a hook to bring in other appellate issues. So it could be that if the Georgia Court of Appeals takes up that disqualification issue, this is something maybe that Steve Sadow or other defense counsel would kind of, add on to that appeal. So we will see. Steve Sadow did release a statement earlier saying that they are still, considering all of their options regarding this denial. So to be seen whether that includes an appeal. We also got another order from Judge McAfee today, though, involving a motion from David Schaefer. We talked about this last week as well, and the hearing that was held on this motion. It was David Schaefer's motion to strike certain language from the indictment in which the prosecution referred to the lawful presidential electors or, false electors, referring to the Trump slate of electors. So David Schaefer argued that that language should be stricken from the indictment, that they're, conclusory statements that aren't necessary to be in the indictment, and that they're prejudicial, all this stuff. And Judge McAfee, and he also said, and while you're at it, you should throw out the charges because the indictment included all of this language that shouldn't have been in there in the first place. Judge McAfee rejected that argument.
And Anna, just clarify for me, how many times does the term fake electors appear in the, I believe it's 91-page indictment?
Oh, I do know the answer to this. I don't think is it any times? I don't think it.
Zero.
Yeah, I think it's zero. I think they refer at one point to false electoral college votes. And then they refer to the duly elected and qualified slate, referring to the Biden electors, but they never use the term fake electors. It's the furthest that they go is false electoral college votes. But yeah, so Judge McAfee rejected this argument for a variety of reasons. He spoke about, we've talked before about how in Georgia, they're very particular about the form of the pleading. This was a special demur. He basically said this isn't the right form of a pleading to kind of raise this. It's not the right time of the proceeding. But he also found that, these statements are allegations that the state still has the responsibility for proving, but that they ultimately are not something that is surplusage, that they're not prejudicial, and that therefore, they shouldn't be stricken at this time. So 2 orders from Judge McAfee that deny some of the latest motions that have been argued. It was a very quick turnaround, but he's been very quick, and I suspect that he will continue to crank out some of these orders on various outstanding motions in the case. So we'll see.
Just want to say, people always, note that Eileen Cannon is a FedSoc judge or a conservative or whatever. Judge McAfee, FedSoc guy from the University of Georgia Law School, and has been, in my judgment, just straight down the line, excellent. You can agree with some of his stuff, you disagree with some of his stuff, but he's moving the case along, he's doing his job, serious guy. So don't paint with too broad a brush about organizations like the Federalist Society.
Well, Judge McAfee also worked for Trump's DOJ. For all of the talk that there was about him having a conflict of interest because he used to work in the same office as Fani Willis and donated a very small amount to her campaign, this is a guy that has Federalist Society credentials, so to speak. He worked in Trump's DOJ. He's not someone that I think would typically be the target of right-wing attacks in the way that he has been.
I just use it as an example, like the big categories that we use are often not the best way to understand how well a judge is going to do his job. They look kind of similar on paper. They're she's a little bit older than he is, but they're both early career judges with conservative backgrounds. He's got a much harder job than she does, just in terms of the number of defendants and the sweep of the indictment. And he's been a model. And so I just pointed out as, people, don't try to make complicated things simple. And, sometimes you get somebody with this type of background and it's very ugly. Sometimes you get somebody with this type of background and it's terrific. And Ben,
one more thing on the Fulton County topic before we move on to something else.
Yeah, well, we're going to go to the Georgia Court of Appeals next, so we're not going to go very far.
Okay.
No, go
ahead. Well, because I think we talked about the Georgia Court of Appeals last week, but maybe I'm misremembering that.
But I just think people need a little bit of reminder about where we are with this. We've got an appeal that he has certified.
Yes, he is certified. They have now filed the application for interlocutory appeal. The Georgia Court of Appeals, in their procedural rules, it's 45 days for them to decide whether they're going to actually take up that appeal. And there's a number of factors that they consider, things about whether it would be desirable to make precedent and that kind of thing when they're considering whether to take up this appeal. They also, and to what extent it affects or the issue impacts the case, that kind of thing. And they have 45 days. There's also a period, I need to check the date when this will be due, but there will be a day when the district attorney's office will have a response that is due, if any. There most recently today, there was one conservative group that I haven't read the filing yet, but filed an amicus brief before the Court of Appeals in support of Trump's appeal. And then typically, though, I think that my understanding is that even though it's a 45-day window, the Court of Appeals tends to make decisions in around 30 days. So we may see a decision much earlier than that 45-day window. Meanwhile, what I was going to mention a second ago is that there is a CNN report that just came out before we started this podcast that says that there are various defense teams who are weighing a gag order on Fani Willis. This is something that was raised by Judge McAfee in his disqualification order because part of the argument that the defendants are making there is this forensic misconduct argument where they argued that Fani Willis made a number of prejudicial extrajudicial statements. There's the church speech, but she has since also made some other comments. Even after this disqualification order came out, she made statements like the train is coming, meaning, that there was nothing that was going to stop the case. So just some other little comments like that I think people have been quite critical of Fani Willis for continuing to speak to the media about the case, even following this disqualification order. And as a result, there's this report that the defense teams could seek to, get a gag order. I would be really surprised, though, if that does happen, because the best thing for the defense right now is to have Fani Willis going out talking to members of the media and maybe slipping up and saying something that she shouldn't, because it kind of supports their idea that there has been forensic misconduct based on these extrajudicial statements and could make for, additional grounds on appeal in terms of when there's maybe if there's a direct appeal, if the Court of Appeals, for example, denies their request for an interlocutory appeal at this stage. But so I'm curious if you guys have a difference of opinion there, but I just am very doubtful that the defense will seek a gag order of Fani Willis or the prosecution team, because what benefits them the most right now is to keep her talking and have her going out and saying things to the media.
Well, what I will just say on this, that I really think that Fani Willis should stop making statements to the media that are not the Lawfare podcast. And she should, however, come on the Lawfare podcast, as Ken Chesebro's attorney did, and we will give her a fair forum to make all kinds of inappropriate extrajudicial statements. And I suggest that all defense lawyers wait till after that to file their motions for gag orders. That's my view on the subject. So, in South Florida and in Fulton County, we do not have a trial date. But in New York, we have a trial date, folks, and it is soon. Anna, bring us up to speed on what's going on in New York.
Right. So New York, I can't remember if we talked about this on the podcast. We might have just missed it, but last week Judge Mershon expanded the gag order that governs what Trump can say about the case. If folks, I think, will be aware of this, but Trump had been posting on his Truth social media account about Judge Mershon's daughter, and then also, I believe, about Judge Mershon's wife. And the prosecution team requested a clarification as to whether that gag order that that Judge Mershon previously imposed covers members of the court's family or court staff, that kind of thing. Judge Mershon promptly responded with an expansion of that gag order, and it involves public statements about the court's family, and then there's also this like additional kind of qualifier on it, though. It's not just, if any public statement is made, it has to be with, someone correct me with the language because I don't have it right in front of me, but it has to be with kind of an intention to interfere with the administration of the case or the administration of justice. Is that right?
Yes.
Yes, and so we have this expanded gag order. Trump, I believe it was last night, posted articles on his Truth Social account that it was a link to an article that had some text from the article kind of previewed on the Truth Social post, and you could see that it was making these claims about Judge Mershon's daughter and about his wife. And so there's a lot of questions from people about whether this could be a violation of that expanded gag order. I think that it's at least towing the line, but it may not be enough to quite get to a violation. So I'm curious what you all think about that.
Yeah, can I speak to this actually? Because I think
Please.
that I had written a piece in November about the gag orders that were issued by Judge Chutkan and Justice Engoron in the New York civil case. And part of the argument that I was making there was that, I think it's very easy to think of Trump as someone who operates on instinct alone, but in many ways he's actually extremely canny and he has a very good sense of just how far he can push things. And what you saw in those instances, so in the New York civil case, for example, that gag order was instated after Trump and his counsel kept talking about Justice Engoron's chief clerk. There were, I believe, 2 violations of that order. Trump was fined. I'm not sure what the total fine was, but the biggest fine implemented at one point was $15,000. And then they stopped. Now, they definitely, there were intimations, but they didn't directly talk about the clerk anymore after that. We haven't seen as much activity in the DC gag order just because the case has kind of been on hold ever since the appeals court upheld and narrowed the gag order that Chutkan originally imposed. But I think what that shows, and what you see in this sort of saga that we've seen with Justice Merchan, is that Trump is very, very good at identifying just exactly how far he can push things. So the initial gag order from Justice Merchan did not include him, did not include his family. Trump immediately went after his daughter. The gag order was expanded. Now Trump is, again, towing the line where he's posting the link and the preview image has information, has a picture of this woman. But he himself is not talking about her. And if you look at the text that he's actually posted himself on his Truth Social page, it's much more along the lines of, I'm being silenced, how dare the court silence me, so on and so forth, which is, of course, perfectly permissible. So I think what this really points to is I would not necessarily expect him to be found to be violating the order. He might. I mean, I think, there's a world in which we go to trial on April 15th. He flies off the handle and posts something, late at night in a fit of rage, and ends up in trouble. But he has been very, very canny about identifying the boundaries of things. The flip side of that is that I think, judges have been unwilling to really bring the hammer down. I think because there's this kind of dynamic where they know that Trump is waiting to say they're silencing him and persecuting him once they do. And so there's this incentive to kind of give him a maximum amount of leeway so that then when he steps over the line, you can say, okay, we tried the nice way. Now let's be a little harsher in the hope that, that gag order holds up on appeal, for example. And the problem is, of course, that, now that he's talked about Justice Merchan's daughter, everybody on the right knows exactly what he means when he says the court is very unfair. And they're sort of primed to go after him already. So I do think that, it's a tough situation for the judges, and I have a lot of sympathy for the court here.
Quinta, is it that the judges go easy on him or refuse to bring the hammer down on him, or is it that they save all this stuff up and cut him zero breaks, give him zero benefit of the doubt in, for example, deciding what fine to issue on behalf of, or what E. Jean Carroll recovers, or the $450 million. There's 1,000 incremental interstitial judgments that go up in those, and the judges in those cases seem to make every inference against him or to stack up. And I wonder if the enforcement mechanism here is, don't expect me to cut you any breaks in sentencing, dude. And it's kind of more of it's more of a deferred thing than it is, because if you do it now and you say, okay, $10,000 a day or whatever your fines are going to be, that's appealable, right? But if you do it and it slows things down, but if you do it, if you just let it pile up, you speed things along. And by the way, you can justify all kinds of things in sentencing or in issuing a recovery judgment.
So I think there's a lot to that. 2 points. One is, I do want to emphasize that Merchan is a bit more limited in what he can do in terms of contempt. If you look at his order, he points to New York's criminal contempt statute, which has, I think, a maximum of $1,000 or 30 days in jail. So he actually has less flexibility there than Justice Engoron, for example, who had the civil contempt statute in play. I will confess, after looking into this, I'm deeply confused about how New York State distinguishes between civil and criminal contempt. I don't know, Roger, if you can help me out there, but the civil contempt statute is not at play here. It's the criminal contempt one, which is more narrow. Whereas so Engoron had some more freedom to kind of throw around really potentially substantial amounts of money. So I do just think that is worth keeping in mind here. There's been some discussion on social media among prosecutors about, whether he could chuck Trump in jail for violating his bail conditions or something like that. I think that's also kind of far-fetched, particularly because of the nature of the charges against Trump, that it's a Class E misdemeanor. It is bumped up to a felony, but the New York bail reform law that passed in 2019, 2020 really limits what courts can do there. All of which is to say, there's a limited amount ability to respond, which goes to your point about, at sentencing, he can really bring the hammer down. I think there is something to that. The only thing that I would raise, and I'm speculating a little bit here, so I would love for the rest of you to, tell me if you think I'm going too far out on a limb. I think we have a hint that in at least one instance that lack of sympathy, let's say, with Trump as a defendant manifested in the New York civil case, and a judgment that was so enormous that I think we have some indication that the appeals court might be inclined to reduce it. And I say that because, of course, the appeals court stayed the judgment against him and significantly reduced the bond There's been some news today also about whether or not the bond that Trump posted is actually consistent with New York statutory requirements. So that's a whole other story. But there's indications that the fact that they reduced the amount that he needed to post as an appeal bond might indicate that they are inclined to reduce the size of the overall judgment against him. I mean, perhaps because, those appeals court judges, unlike Justice Engoron, didn't have Trump screaming at them and sending threats after them. So, that dynamic can really go both ways.
There's one additional remedy that Merchan mentioned. I don't know again if he would actually do it, but in the original gag order, the people had asked for an instruction that if he continues this harassing and disruptive conduct, that he could forfeit his statutory access to juror names. And that was denied the first time around, and this time he granted it. Now, I don't know if he would really do that, because it's right in the CPL, the criminal procedure law, that defendants are supposed to have this. You could create an issue about whether that's a due process thing. It's done in the federal courts in very dangerous criminal cases. There are anonymous juries where the defendant, where neither party knows. In fact, even the E. Jean Carroll case, there was an anonymous jury where neither party knew. But it's not clear whether you can do that. There's some cases saying you can in New York, but not doing it. So it's not great. But anyway, there's a little game of chicken going on there.
All right. Before we go to audience questions, two things. One is I have a very important set of announcements about this trial, but that's just a teaser for those announcements. We want to talk on the tribulation side. We have left the trials side, although there's kind of a trial going on. It's a trial and a tribulation. Last week, of course, we had the judgment or the recommended judgment in the Eastman.
Wait, we have one more thing on New York that we should mention. Okay, is this what you're about to?
No. Correct me. What did I skip over?
Okay, yes. So sorry. Just before we move on to the bar disciplinary hearing drama. In New York, we also had this order on Trump's motion. So it was a presidential immunity motion that he made after all of these other pretrial motions had already been kind of filed. The time period was basically over. He tried to recast this motion on presidential immunity as a motion in limine. So a motion to exclude evidence. He argued, because usually, in the case, the immunity case, for example, that's going to the Supreme Court in DC, it is an argument that Trump is absolutely immune from criminal prosecution, that he has a right to just not stand trial, period, as a result of the doctrine of presidential immunity. But what Trump tried to do here was carve that immunity up into an evidentiary privilege, meaning that he was saying that basically anything that is evidence that would usually the prosecutors wanted to submit at trial that related to official communications that he made while he was president, that under the doctrine of presidential immunity, they would be barred from using that evidence because of, all the reasons that he's given for, coming up with this very expansive notion of presidential immunity. And so Trump made this argument. Judge Merchan issued an order yesterday on it, in which he denied the motion. Trump, in that same motion, had also asked Judge Merchan to basically put the trial off until the Supreme Court decides the DC presidential immunity appeal. And Judge Merchan also, declined to do that. And the reason that he made this order is not even related to the merits of the argument, which I think would have failed anyway, but it related to the timeliness of the motion. Judge Mershon basically said, you filed this too late there, and he went through a number of different reasons why Trump should have known and had every opportunity to be able to file this at an earlier time. So he denied the motion as untimely. I think that he can appeal that denial, even though it's not based on the merits, it's based on the timeliness. But there was a similar issue that arose in the Carroll case regarding a timeliness motion, and the appellate division of the New York court system denied, or excuse me, the relevant appellate court denied that motion to appeal based on the timeliness issue. And so I think that we would have a similar outcome here. But someone correct me if I'm misremembering that. But yeah, so I think that we will be going to trial on the week of April 15th is when jury selection is set to start.
Right. And all right, we will come back to that in a minute. Quinta, let's talk about bar disciplinary proceedings. As we speak, we've got a Jeffrey Clark trial. Quinta's been a little bit quiet on this episode. It's because she's actually monitoring the Jeffrey Clark stuff even as we speak. So she's got like different windows, and one of them she's on TV, and the other one she's watching Jeffrey Clark. So don't ever say you can't multitask. Quinta, what's going on in the Jeffrey Clark matter?
So listeners will probably recall last week we got an initial ruling by California State Bar Court that John Eastman should be disbarred. Eastman has said he will appeal that, and now we have across the country a sort of parallel proceeding in the Clark case. So both parties rested today, and the hearing committee reached a preliminary decision that Clark had violated at least one of the rules of professional conduct that the bar had charged him as violating. So that's in particular Rule 8.4, different components of Rule 8.4 of Model Rules of Professional, the DC Rules of Professional Conduct. One of the charges against him accused him of conduct involving dishonesty, the other of attempt to engage in conduct that would seriously interfere with the administration of justice. And of course, both those counts have to do with Clark's effort to sort of take over the Justice Department and send a letter to the Georgia State Legislature indicating that the Justice Department was concerned about election irregularities in the wake of the 2020 election as part of the effort to sort of overturn the 2020 vote and hand Trump a second term. So the Clark trial has been going on for the last 2 weeks. Anna and I have both been watching. It has been a rollicking ride. And today, so we did have the hearing committee reach this sort of preliminary decision. They're now hearing arguments about what sanction is appropriate. So Clark's counsel has been arguing as we speak, so I haven't heard what he's been saying, but the disciplinary counsel, Hamilton Fox, basically came right out and said, we think that disbarment is appropriate. And explicitly drew a comparison to the Eastman case, and essentially said, these are both instances in which lawyers attempted to, overthrow a legitimate election, and compared it explicitly to the crisis that the United States faced in 1860, and said that it was, the sort of the second greatest crisis that the United States had seen along those lines. And so, therefore, that sort of lack of fealty to the Constitution merited the most severe of penalties, disbarment. Sorry, go ahead.
Yeah, so a couple of lighter notes on this. You mentioned Hamilton Fox's argument, but the defense in this case compares it to another really important case in the history of the Washington, not to the Civil War and to the secession crisis and whatnot, but to another really important case in the history of the DC bar discipline system. What is that case, and are you joking?
So I think you're actually thinking of the Giuliani case here, Ben.
Oh,
Are you, if
I'm
you're thinking
sorry.
of the
Do I
pair of
have the
pants?
wrong case?
So
Oh,
yeah,
I'm so sorry.
no. So
Set
what
up this
Ben
wonderful
what Ben
joke
is
and I got the
referencing
premise wrong. I'm sorry.
what Ben is referencing, and we really are not joking, and let me do a little bit of setup for this, is that the bar authorities have been kind of hampered in all of these cases by the fact that there really aren't there's not that much precedent to guide them in terms of
Lawyers
what sanction
don't
is appropriate.
usually try to overthrow the republic.
Exactly.
It's just not like clear what the
Right.
precedents for that.
And so in the Eastman case, the Judge Yvette Rowland of the State Bar Court actually said the closest example she was able to find was the case of Donald Segretti, who might sound familiar if you've seen All the President's Men. He was one of the dirty tricksters employed by the Nixon campaign. And he faced bar discipline as a result of his actions following the Watergate scandal. His law license was suspended for 2 years. And Judge Rowland essentially said, okay, well, I think this is a lot worse than that. So I'm just going to go with disbarment. This came up in the Clark case, this sort of lack of comparable precedent in arguing for Clark's disbarment. But one case that I believe, unless I missed it, Fox did not mention was a case that came up when he was arguing for Giuliani's disbarment. So Giuliani, of course, the hearing committee recommended he be disbarred. We're waiting now for the sort of next level of the board on professional conduct to decide whether that disbarment should hold. I can't even say it without laughing. Under the specific rule of professional conduct that Giuliani is alleged to have violated, Rule 3.1, so filing a frivolous suit, there is a case in which a DC lawyer filed over a dry cleaner that lost a pair of pants. And by the end of the litigation, he was demanding not $67, not $670, but $607 million in damages. I guess because he really liked the pants, I don't truly know. But his law license was suspended for 90 days. So there's a bit of an odd exchange in hearing in the Giuliani case where the hearing committee chair essentially says, well, you have this precedent in the Pearson case, the pants case, that's 90 days, you're asking for disbarment. That's a big leap. And Fox sort of says, you're not wrong, but that was a pair of pants. And this is trying to overthrow the government.
So for those of you who do not remember the 90s in DC, I don't know, Roger was in New York then. We were both working for the American Lawyer media company, and we had a freaking field day with this case. It started like long before the bar disciplinary case. It was like the lawyers, the dry cleaner lost the lawyer's pair of pants, and it was like,
do we know, were they like a particularly exciting pair of, were they made of solid gold?
No, there was nothing especially special about the pants. I do remember that at around the same time or shortly before this happened, a dry cleaner lost a pair of my mom's pants, and she never, of course, sued for $67 million or whatever it was. But it hit quite close to home for us because it turns out there were remedies that we were unaware of.
It's hard to find a good pair of pants.
It is hard to find a good pair of pants, and when you find one, and then a dry cleaner goes and loses it on you, sometimes it has to end in litigation. All right, we are going to go to audience questions now, but before we do, I have a very important set of announcements to make about what is going to happen to Trump Trials and Tribulations, not on April 15th, but on the day of opening statements. Which we don't know what day it is. Trump Trials and Tribulations will continue on Thursdays at 4 o'clock until the day of opening statements. But on the day of opening statements, it will shift. The weekly roundup will happen on Wednesday, which is the day of rest in Judge Merchan's courtroom. And we will be going to daily live streams. They will be much briefer. They'll be about half an hour. That will be Trump Trials and Tribulations daily roundup of the New York case. And those will be whenever Anna and I, and sometimes Quinta and sometimes Roger, get out of court. So we're not exactly sure what time they will be. They may vary from day to day, depending on how long things go. They will run on the Lawfare podcast feed, and we will be working with our friends at Goat Rodeo to do this. So that for those of you who watch on YouTube, they will be daily streams. For those of you who listen on the podcast feed, they will be a separate entry on the Lawfare podcast feed. They will happen daily. And the long one, the weekly roundup, will move from Thursday to Wednesday. And that will continue for as long as the New York trial is in session. We will not be taking questions on the daily roundups because we don't know precisely what time they will be, so those will be informational only. So that is the, as they say, plan O action. Let's go to audience questions. We have 14 of them, and I'm going to get through them all. Everybody wants me to read the questions today. It makes it so easy. XYZZY asks, the Supreme Court framed a really weird question for itself in the Trump immunity issue. Whether and to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? First of all, the word alleged completely confuses things. It sounds like there's a double allegedness going on, one for the trials and another for the acts. Maybe SCOTUS meant to say for alleged conduct involving official acts. More importantly, because no specific acts are listed in the question, answering this per se question has no direct impact on any specific case. All that it does is say that some acts carry immunity, which of course they do. The problem is that because some acts, of course, carry immunity, SCOTUS is going to answer the question yes. But the public will read this as meaning that Trump has immunity in these particular acts, which would be a misreading of a yes response to the per se question. All that answering the question either way can do is start a massive food fight about the specifics of a given case. All right, who has thoughts on this question, which has a number of constituent elements?
Well, I think I'm going to defer to Ben or Quinta on most of this, but just say that, I just don't, where they go from here on a question presented seems sort of speculative. They're certainly interested in hearing about whether official acts plays any role. Beyond that, I don't know how much to read into the question presented, which was a little ungrammatical to me.
Correct.
Yeah.
Q, do you have thoughts on the question presented? Quinta? She might be watching television.
I'm sorry, I had flagged that I was watching Clark. What was the question?
Don't worry about it.
He's done now.
Oh, okay. I will say the following on this question. The questioner is correct that the question is worded oddly. The facts of the case, however, are not worded oddly. There is an indictment. Everybody is confined to the facts of the indictment. The president claims, former president claims immunity on these facts. The Justice Department claims that there is no immunity as to any of these facts. And the DC Circuit agrees. That is the opinion under review. And the Supreme Court can word the question presented any way they want, but either they have to hold that there is immunity that does or does not apply to these facts, or may, in which case you'd have to remand, or you have to hold that there's no immunity that does or does not apply to these facts. And I don't think the nature of the wording of the question presented fundamentally alters that, at least not very much. But I do agree with the question that there is something to be, I don't know if concerned about, but puzzled about in the way the Supreme Court framed the question. All right, John asks, why is the demeanor of Trump's lawyer and other defense lawyers in the Georgia case so different from the hijinks of Trump's lawyers in the other cases? How long will Trump keep allowing professionalism on his behalf? Anna, get us started on this. Do you have thoughts on the professionalism of Steve Sadow?
You know, I've been thinking about this a lot, and because it's a question I'm really curious about. What I maybe have come to think is that in the federal cases in particular, and maybe to some, I mean, New York, it's, got some overlap with the federal cases because Todd Blanche is leading that prosecution alongside a local attorney, Susan Neshles. Is that how you say it?
Necklace.
Okay, thank you, Roger. Apologies for mispronouncing the name, but I think that maybe the answer has something to do with kind of what representing Trump does for these various attorneys, so or Trump's co-defendants. So in the case of, for example, someone like Todd Blanche, he started his own practice soon after, I believe, he started representing Trump, and is, representing Trump as kind of the main bread and butter of his practice, and may have some career aspirations that if Trump is elected, then maybe there's a position waiting for him in DOJ or in federal office of some sort in that administration. But then when it comes to someone like Steve Sadow, I mean, Steve Sadow is going to continue being a defense attorney in Fulton County, Georgia, in Atlanta, once he finishes representing Trump in this case. And that's the similar kind of thing for these other attorneys who have also been, for the most part, incredibly professional in terms of their representation of the co-defendants in that case. They are going to continue on to be local Fulton County, Georgia attorneys. And so there's an element to which, they have different incentives to continue to keep things maybe within the more reasonable kind of bounds of argument, and just ways of acting in court. And so I think maybe that's what I'm leaning towards right now, is just how there's a different kind of calculus there in terms of the career aspirations and kind of professional incentives for some of these attorneys. Todd Blanche, I don't know how many cases after this he's going to be, doing a criminal defense attorney work in the Southern District of Florida. I just don't know that he's all that concerned about, continuing to and particularly because it's before Eileen Cannon, it doesn't really matter, the arguments that you're making there if they're really kind of fabulous, because she seems to be on board with them. But I think that what it comes down to for me is just that kind of local versus. I don't know what the word is, but having just different kind of career prospects and reasons why you're taking the case. Does anyone disagree?
I also think one factor is that, how close you are to trial. The closer you are to trial, the more outrageous you have to be, because eventually you have to defend the conduct. And if you're Steve Sadow, you can hide behind Ashley Merchant as she goes after Fani Willis on, frankly, grounds that are not, like Fani Willis made herself very vulnerable. And so Steve Sadow can kind of sit back and let Ashley Merchant do a lot of the heavy lifting. If you're Todd Blanche, you can't do that. You've got to get ready for a trial in which a porn star and the aptly named David Pecker are going to testify. I mean, it's so there's just they're not similarly situated in their what the job is calling upon them to do. All right, the next question comes from Simon in Montreal. Quinta, thinking about your black hole scenario leads me to wonder about the Trump trial that doesn't exactly involve the former president. What do we know about the current status of the billion-dollar Smartmatic lawsuit against Fox News, and why is reporting on it so scarce? So this is not necessarily for Quinta, but does anybody know what the status of the Smartmatics suit is?
So I know there was this sort of confusing back and forth where Fox had filed a counterclaim, which I just Googled, and it looks like a judge ruled that they can't just squelch out right out of the gate. I believe there was some activity recently concerning discovery, but I confess I have not been following super closely if anyone else has.
I have not. So let's say we will get back to you, Simon, in Montreal next week, unless somebody else knows more.
Yeah, well, I also, was it the Smartmatic suit that there were recently issues with, crime fraud, like there was some kind of discovery issue, and there were a lot of briefing back and forth about the crime fraud exception or something, because it related to efforts to get just never mind. Let's talk about it next week. I will do my research because this is coming out more half-baked than I thought it would.
All right.
But yes,
Gray,
we will get back to you.
Gray asks, on several occasions you all have said of Judge Cannon that she has eventually to rule on something. But what if she doesn't? I'm familiar with the process you have described for how prosecutors could take an egregious ruling by her, ask her to reconsider, then escalate to the 11th Circuit. But what if she avoids ever getting to that point? If she literally kept avoiding ever actually ruling on anything of substance, and if Trump loses in November, what would happen in 6 months, or in a year, or in 2 years? All right, so I will say a couple things about this. One, that as Roger pointed out, there are cases where judges have just sort of refused to rule, and sometimes you can mandamus the absence of ruling. But it's tricky, and the question of how long is reasonable, I mean to look this case up, but I remember sometime in the 90s when I was at Legal Times as a young reporter, there was a case where the DC Circuit removed a case from a judge after he sat on it without ruling for 23 years. and that was done by mandamus. I need to pull the case, and because I keep coming back to it with Eileen Cannon in mind. Like, how long would she have to sit on something? The short answer is, um, in a in a case like this, uh, the 11th Circuit would lose patience faster than 23 years, I think, is the most I can say.
I think we're going to get a ruling and an appeal to the 11th Circuit in something. There's too many motions, and there's too many where I don't think she can say no to Trump. And, there is this unsworn, I mean, whether to unveil the redactions. I don't know if she's going to want to back down. Maybe she can modify it and try to make it palatable. I don't know if that's the best case to go up for Smith, but I think he might. Then he's got his own immunity argument, and it hinges on that alleged act. There's this theory that Trump has, that she has, that the mere act of absconding with the classified documents means you have de facto designated them as personal. And that occurred during the Trump administration. So that would be an official act, in her world and in Trump's world. And so that would sort of that would be protected by immunity, and it's sort of integrated into the whole case. So there's a lot. I also don't think she can turn him down on the selective and vindictive prosecution, which is another really out there claim. It has nothing to it. At that hearing on March 14th, she seemed to be locking in on it. She seemed all in. I don't think she can back down there. So I just think something's going to go up.
All right. Gray also asks, this is clearly for Quinta, I get that disbarment is a serious affair, but good grief. The various proceedings against Eastman Clark and assorted other lawyer coup plotters have been going on for upwards of 3+ years, right? As in, these take way longer than almost every capital punishment case. Also, how is it that the state and federal judicial bodies seem to be formally interwoven, what with appeals, requests for injunctions, etc., seemingly a part of the process? For instance, I've read that Giuliani's DC disbarment is ultimately reviewable by the DC Court of Appeals. How is that part of their day job? So I'm going to defer to Quinta on all of this, except this last point, which is factually incorrect. The DC disbarment is appealable to a different court, which is the DC, not the DC Circuit Court of Appeals, which is a federal court, but the DC Court of Appeals, which is basically the local. It's like the Supreme Court of DC. We don't have a mid-level appellate court, just a court of appeals. So it's not an interweaving of the federal and state systems. Quinta, is this stuff taking too long? Should they just, do like the French Revolution and, guillotine their bar licenses the same day?
Yeah, I mean, I want to say capital punishment cases take a really long time because there are a lot of appeals and there are a lot of different habeas petitions. So it's definitely not taken longer than that. Yeah, I mean, look, so the Eastman case, I think, I don't have the dates in front of me, but it took about a year from when the bar announced that they were pursuing charges against him, I think a little over a year, to the actual judgment. That case kind of took a while to get off the ground. There were others that had moved forward more quickly. I think Giuliani's was the sort of at the head of the pack. But look, I mean, these cases, they take time to build. You have to investigate. I actually think that the Eastman and Clark disciplinary cases have benefited a lot from the evidentiary record that was put forward by the January 6th committee, in terms of, you know, what is now sort of in the public record in terms of the conduct that they both engaged in. Obviously, the bar has to provide their own evidence, but just in terms of, you know, giving them a head start. I believe there are certain due process requirements in a proceeding like this, because it is a state. This is the state that is, or the state court rather, that is taking action against you. Although I'm not precisely sure, how much is required there. But it's not, you don't want a system where the state bar is basically able to swoop in and say, we don't like you, we're taking your license now, right? Like, it is good for there to be some level of process. That said, yes, it is slow. It is sort of in some ways mismatched to the egregiousness of the conduct. Once you've tried to overthrow an election, having someone kind of slap you on the wrist and saying you can't practice law anymore seems like kind of like small potatoes. On the other hand, I mean, the criminal proceedings have also taken a really long time. Like, on some level, just having sort of the plotting process of investigation, and institutions going through some kind of process to implement accountability is just how things work. And I don't know if there's really much of a way around that, unfortunately.
Could I add one
Yeah.
thing? Well, in Giuliani's case, in New York at least, I think there was a pretty swift interim suspension, which used to be unusual. So that was something that, you quickly take him out of action.
Although the New York, we still don't have a final ruling in the New York case.
Yeah,
like
but
2
he's
years
not,
later.
he can't practice in the interim. And with Roy Cohn as a comparator, I think his bar proceedings lasted more than 16 years. And he was not disbarred until 1 month before he died. He was on his deathbed dying before he was disbarred. And I don't think it's irrelevant, when you have these people that are powerful, that have money, that have what Tom Wolfe used to call chits in the favor bank. It's hard for them. It's not necessarily hard to disbar, the average schlepper without friends. It's hard to disbar a powerful person with money.
All right. I want to get through the rest of these questions. We have 8 minutes. I'm going to consolidate Mark and David's question because it's really the same. They both ask, what happens to the Florida, DC, and Georgia cases if Trump wins the election, both in the interim, before he takes office, and after he takes office? I will handle this one myself. My colleague Scott Anderson and I were asked by our friends at the Democracy Fund to put together a presentation on exactly this issue. The people that we presented it to were so flabbergasted by our answer that we thought we would record it for the Lawfare podcast, which we did. And we gave what I think is a very neutral presentation on the subject, just trying to analyze what the rules are and what the laws are. And that is available both on YouTube and on the Lawfare podcast feed. And we will share it in the links and in the show notes for this show. The short answer is there's a lot of unclear law, or maybe I should say there's very little clear law on the subject. But basically, if you win the presidency, neither the state of Georgia nor the federal government is really going to be able to lock you up. The period of the interregnum is a very complicated little question, and we go into that in some depth in the discussion. Rachel asks, if someone does physically attack Judge Merchan's daughter as a result of Trump's statements, aside from any other impacts, would that require Judge Merchan to be removed from the case? Is it possible he's actually trying to get this woman hurt because it would benefit him? That, I assume the he there is Trump. If this did have to be reassigned for that, how would a new judge be able to take that into account? First of all, I just want to make clear, neither the question nor any of us is contemplating with anything other than horror the attack on, an attack on the judge's daughter. It's a fair question because the former president, keeps raising it with his conduct. I think, first of all, if somebody did attack somebody, I don't actually want to talk about hypothetical attacks on individuals, but somebody covered by the order, let's say, I do not think that would trigger a necessity for Judge Merchan to recuse. It would require the a question of whether that was in some way inspired by or animated by a violation of the court's order, and he would have to enforce that order. I don't think, to answer your question, that you can create a conflict on the part of a judge by attacking his family and then say, look, he's got a conflict because I attacked his family. It's actually pretty close to the old definition of chutzpah, which is killing your parents and then pleading for mercy because you're an orphan.
And remember that both federal judges here have been the subject of death threats directly to them that are being prosecuted in federal court, and neither has, one from the right, one from the left, presumably, and that's how it worked. And neither has no one suggested that they would need to recuse themselves.
Well, yeah, not just threat, and Judge, at least in Judge Chutkan's case, and I think there was a report about Judge McAfee as well, who were swatted, which goes a little bit beyond, or not just a little bit, it goes well beyond, just the realm of threats, which themselves are terrible. But so there is certainly something to, that has happened to people who are involved in the case, and it hasn't been sufficient to generate a conflict.
All right. Philip asks, can the factual findings in the civil trials be admissible by themselves in the criminal trials, or must they be proved again? They have to be proved again because the standard in criminal trials and the standard in civil trials are completely different. So the fact that you've proven, for example, that Trump sexually assaulted E. Jean Carroll to the standard of a preponderance of the evidence does not mean you have proven the same fact to the standard of proof beyond a reasonable doubt. Jeff asks, can Justice Merchan order a psychiatric evaluation of Trump if he violates the gag order? The answer is, if there were to be a motion for a psychiatric evaluation that showed a reason why one would be necessary, he could grant that motion. It would be very unusual for him. Judges don't normally, when they are faced with a violation of one of their orders, say only a crazy person would violate my order. You must be a crazy person. Go get a psychiatric evaluation. Normally, what they do is try to enforce their orders, and maybe the defense would say, actually, no, he might be crazy. We need a psychiatric evaluation. That would be the normal way to do it. The defense, of course, will not do that in this case. So I think don't hold your breath for a psychiatric evaluation, though I would love to see one. Kevin says, I vaguely recall you saying a couple weeks ago that you expected the Georgia Appeals Court to act quickly if they were going to refuse to take up the disqualification appeal. Are there any tea leaves to read in the fact that they have not decided yet? I think you are misremembering. What we said we expected was that Judge McAfee would not certify the matter for interlocutory appeal, and we were completely wrong about that, and that he would do that quickly, and that we were right about that. That said, Anna, do you think there are any tea leaves to read?
Not at the moment. I don't think there are any at the moment. You know, I still am not entirely sure what the Court of Appeals is going to do. If I had to guess, I would say they're going to decline to take the case. But I said that about Judge McAfee and the certificate of immediate review. So I was wrong then. I might be wrong now. But there's no tea leaves right now. We don't have any kind of order on, a stay or anything at all from the Court of Appeals. So there's nothing right now really to go on other than that we're going to get a decision, within the next,
3
was it
weeks or
Friday?
so.
Yeah,
4 weeks.
yeah, 3 weeks. So.
All right. Catherine asks, do you think Trump's next move to delay the 415 trial will be to fire Todd Blanche? No, I don't think that will happen. Do any of you disagree?
No, I think he's gonna, surely he's going to try to appeal this immunity issue and ask for a stay of the trial or something like that. But I don't think it's going to succeed.
All right. Yeah, I think we're going to trial on 415. Arnold asks, when the J6 immunity cert was granted, a different number of votes were required for certiorari than for extending the stay, so they were separate. In late April, when the court hears the immunity arguments and sets about writing the ruling, is there any chance that the stay could be lifted to expedite the trial, or would that be too burdensome? So, look, the court can do whatever it wants to do. It could rule tomorrow, like hear arguments and rule tomorrow like it did in Ex parte Quirin and say a decision will follow. It doesn't do that very often. The German saboteurs case is the only case I know where they've ever done that. But they can do whatever they want. I think the fact that they did this the way they did it, the slow plodding expedited fashion, suggests that they will move in a slow plodding expedited fashion, and I am looking for a ruling in mid to late June myself. Roger, Quinta, do you have any dissent from that?
No, that's how I read it too.
No, just one note of pedantry that it wasn't technically a stay. It was an order to the appeals court to continue withholding the mandate. And I mention that only because there's a very good article by Jack Goldsmith and one other co-author whose name I apologize, I've forgotten, on Lawfare about the court's use of that maneuver. And my personal conclusion after reading their very good write-up was that, to use a legal term, the court was just making stuff up. Presumably because they didn't have the votes for a stay. So who knows what's happening over there.
All right. Joseph writes, to paraphrase what I hear some folks saying, what's the point of all of this? Even in the best case scenario, how can these cases lead to accountability, much less justice? What can we achieve with these cases that ballots and bullets won't undo soon after? Well, first of all, let us hope that bullets will not be involved. We do not condone violence, nor do we tolerate it. Look, the justice system is the justice system. You go to war with the justice system you have, as Don Rumsfeld might say, not the justice system you wish you had. And so if you believe that it is important to have accountability, you've got to use the accountability mechanisms that are available to you. And if you find you don't like them or they need improvement, that is a policy question that you might need to address. But I'm not sure I understand the logic of giving up on seeking justice and accountability because you don't find the mechanisms available for it fast and sure and adequate. I will leave it at that. If others have additional thoughts, please chime in. Matt asks, is there even a small remote possibility that the special counsel has a sealed indictment docketed in the DC District Court for Insurrection Act charges? I don't think so. Does anybody else?
I don't think so.
Especially because it seems like the grand jury disbanded a while ago.
Yeah, you would need a grand jury, and there's been no evidence that one has been convened.
And you would also need a reason for it being sealed, and there's no obvious reason for it being sealed. All right, last question comes from Diana. Will one or more of you come to speak at Maryland's largest and most active Democratic club, the Montgomery County Women's Democratic Club, to give us the 35 to 45 minute summary plus Q&A of Trials and Tribulations at any point between now and January 21st, 2025? Yes. And that brings us to the end of this week's Trump Trials and Tribulations. So folks, you know,
is there a 501c3 issue? Are you...
I'll speak at a Republican club too. I have no problem. I'm happy to speak to partisan organizations. In fact, I will speak to the RNC if they will have us come talk about Trump's Trials and Tribulations, even to the Trump campaign itself, if they want a presentation. I will give the same comments to all comers. This has been an episode of Trump Trials and Tribulations. Our audio engineer is the great, and video engineer is the great Anna Hickey. Folks, you may be wondering out there in YouTube land, why did they answer Diana's question and not mine that I left in the YouTube chat? And there's a reason for that, folks. It is because she is a material supporter of Lawfare and you are not. So you can remedy that. Go to www.lawfaremedia.org/support. Become a material supporter of Lawfare. Then you get to enter your questions, like your invitations to us to come speak to your club, and we will answer them. We try to get through all the questions every week, even if we run 7 minutes long like we did this week. We will be back next week. We're going daily when the trial starts, from the Sausalito Golden Gate Bridge studio, the Scott studio, the Ansel Adams studio, and the special demurrer room. Take it easy.